Welcome to Module 3, Harassment, Intimidation, and Bullying. The basis for this module is to create safe learning environments that promote health and well-being for all the children in Cincinnati Public Schools. This module will cover harassment, intimidation, and bullying that occurs verbally or physically at school and on school buses and or through the use of technology. Also included in this module is awareness of and action to take when school staff or faculty witness signs of teen relationship abuse. Healthy relationships among community members are the foundation for a safe community. Schools are just one part of a larger community. They are also a community unto themselves. Healthy relationship skills, therefore, must be taught, learned, and practiced not only in the home, but in the community and the schools as well. We are very pleased to have Daniel Hoyning, Associate Legal Counsel for Cincinnati Public Schools, to address this very serious issue of bullying, intimidation, and harassment that could impact a safe learning environment for all of our students.
Good morning, good afternoon. This module will cover training on harassment, intimidation, bullying, and teen relationship abuse. My name is Daniel Hoyning. I'm the Assistant General Counsel at Cincinnati Public Schools. Graduated from the University of Chicago Law School and started my legal career at Taft, Stettinius & Hollister in the Labor and Employment Department. I started representing CPS in cases shortly after working at Taft, and in 2011 I became a full-time employee of CPS. As a labor and employment attorney, I routinely make presentations to employers and employees about workplace harassment issues. And since working at CPS, I've also started helping to advise CPS on cases involving student harassment and bullying. I've helped to investigate and to resolve harassment complaints from parents or students or reported by CPS staff. And I've also assisted CPS in investigations conducted by the Ohio Department of Education and U.S. Department of Education Office of Civil Rights alleging harassment and discrimination issues. Let me first explain why we are putting this training together for you and why you're being required to view the training. Ohio Revised Code 3319.073 requires that all school districts provide in-service training for its employees. All teachers, nurses, counselors, school psychologists, and administrators are required to undergo at least 4 hours of in-service training within their first 2 years of employment at an Ohio public school, and then every 5 years thereafter. And the training must include topics such as child abuse and violence prevention, prevention of substance abuse, promotion of positive behavior supports. There must be content on human trafficking, content on suicide awareness and prevention, and training on the board's policies related to harassment, intimidation, and bullying, and the prevention of teen dating violence. And that's the topic that this module will cover. The goal of Ohio's mandatory training is to ensure that every school in Ohio is staffed with professionals who are trained to respond to these issues. And specifically with respect to bullying and harassment, there are some pretty staggering statistics from the Ohio Department of Education. According to ODE, as many as 30% of teens may be affected by issues of bullying, harassment, and intimidation. And why is this important to you? Well, of course, academically, students who are bullied have a harder time concentrating on school and on schoolwork. Schools have a role to help students remove barriers to learning, and that would include issues of student bullying or harassment. Students who are bullied experience low self-esteem, depression. They're more likely to be engaged in substance abuse, self-harming activities, including suicide. There have been suicides linked to student bullying. Moreover, students who are bullied can and do become more aggressive themselves and violent toward others, creating what ODE refers to as the cycle of violence. School-age children do not always have the skills they need to try to break that cycle. They lack or are learning skills in self-advocacy, understanding boundaries, assertiveness, communication skills, empathy toward others, and a responsible way to use technology and electronic communication devices. School professionals, on the other hand, are often in the best position to intervene and to stop harassment, intimidation, and bullying. Another interesting statistic from ODE, according to the department, 71% of teachers report that they always intervene when they observe bullying or harassing behaviors. But according to students, only 25% of students report that their teachers always intervene when the teachers have observed a bullying situation. The goal of this training is to ensure that 100% of school professionals in our district are trained to recognize and to root out issues of harassment, intimidation, and bullying, and teen relationship abuse. So in this presentation, I'll focus on three areas. One is recognizing harassment, intimidation, and bullying. There are different definitions of harassment under state law, Ohio law, and under federal law, and I'll address both. Second is prevention. The strategy that ODE recommends and that we're advised to provide training on is not complicated. It's a three-step process to intervene, and we'll discuss that three-step process in this presentation that professionals can use to stop bullying. And third, we'll discuss reporting obligations, both under the law and under CPS's board policies. So to start, to discuss recognizing bullying. The Ohio definition of harassment, intimidation, and bullying is, to quote, repeated, intentional, and aggressive conduct by one student or a group of students against another student or students who are perceived as being weaker or having less social power than the person doing the bullying. Ohio law expressly defines harassment, intimidation, and bullying in this manner, and it prescribes that all Ohio school districts develop policies and procedures to define bullying and intervene when there are situations of bullying that are observed and to report bullying. Sometimes I'm asked by teachers or school administrators, what is the difference between harassment and the difference between intimidation and bullying? And under Ohio law, you'll always see those three terms together as if they are a single concept. However, you'll always see kind of these three components of the definition. That it has to be repeated, that it's intentional conduct, and that it's aggression against a student who is perceived as weaker. So that covers the Ohio definition of bullying. The federal definition that is significantly different. And this is a presentation that is required by Ohio law and intended to address Ohio law. However, I think it's worthwhile for you to also understand the federal definition of harassment. The federal definition is derived from federal discrimination and civil rights laws, including Title IX, which prescribes that no person in the U.S. on the basis of sex shall be excluded from participation in the benefits of an educational program or activity that receives federal financial assistance. So Title IX addresses sex discrimination. Title VI prohibits discrimination on the basis of race, color, and national origin. The Rehabilitation Act, Section 504, which many of you are familiar with, intervention specialists in particular, and the Americans with Disabilities Act prohibit discrimination on the basis of disability. And the concept of harassment under federal law is derived from discrimination law. So where students, where a school district is discriminating in the terms and conditions of its educational program and benefits on the basis of one of those protected classifications, that would violate federal law. And harassment is derived from that. If one student or group of students suffers harassment and it becomes so severe and pervasive that it is essentially a term and condition of their participation in those educational program and benefits, then that's prohibited by federal law. So under federal law, the concept of discrimination, again, involves three components: verbal and nonverbal acts, or name calling. It's got to be, there's an action. Second, it has to be sufficiently severe and pervasive or persistent to interfere with the student or employee's ability to enjoy the benefits of the educational program or activity. And third, and this is different from state law, the federal concept of harassment must be based on a protected classification, such as race, color, national origin, religion, or disability status, or sex. If that form of harassment is occurring and CPS is not responding to assist the student, it could violate federal law. Another concept that is included in Ohio's definition and the federal definition of harassment is teen relationship abuse. Teen dating violence is a pattern of actual or threatened acts of physical, sexual, and/or emotional abuse that is occurring in a romantic relationship, a current or former dating relationship. Teen dating violence is more prevalent and less recognized than other forms of harassment and bullying. Again, the statistics are pretty grim. Audrey Kostin-Shelton, who is our lead psychologist here at CPS, showed me a study that said that in 1 year in Hamilton County, about 700 teenage girls are injured in automobile accidents. 700. About double that number, or 1,400 teenage girls, will have babies in a given year in Hamilton County. About double that number, or about 3,300 teens, girls, will take up smoking. But an even greater number, 3,700 teenage girls in Hamilton County, will experience teen dating abuse or violence. Given that it's so prevalent, it's curious why it is less recognized, or perhaps why we are paying less attention to teen dating violence. And Dr. Kostin-Shelton suggests two possibilities. One, because teen dating violence is occurring in a more private, intimate, romantic relationship, it is less obvious. It's hidden and it's out of view. This is not necessarily the type of bullying or harassment or abuse that's going to take place in the school cafeteria or on the school playground. It's out of view. And second, statistics suggest that teen dating violence is significantly underreported. I should note that teen dating violence is not specific to heterosexual relationships. And you should know that CPS's board policies prohibit discrimination at CPS on the basis of sexual orientation. The U.S. Department of Education and Office of Civil Rights has said that it considers discrimination on the basis of sexual orientation to constitute sex discrimination in violation of Title IX. They've also suggested that gender identity discrimination or discrimination against transgendered individuals also violates Title IX. And actually, some experts say that teen dating abuse and relationship violence may be even more prevalent in homosexual relationships. For example, abusive teens have used the threat of outing the other student, their partner, to bully or gain undue control in that relationship, such as by using the threat of revealing their partner's sexual orientation to others, such as family, friends, classmates, as a means to control. So teen dating abuse and teen relationship violence is prevalent in both heterosexual and homosexual teenage relationships. So we've discussed the Ohio definition of harassment, intimidation, and bullying. We have discussed the federal definition of harassment, which is based on a protected classification. And we've introduced teen dating violence. And while the definitions are separate, I think you can see that conduct can fall into multiple categories, that there are commonalities between the three definitions. Here are some examples of behaviors that could fit into one or more of the definitions of bullying and harassment under state and federal law. Physical abuse, probably the most direct and obvious. Punching, hitting, shoving, kicking, throwing, grabbing, shaking, slapping, and punching are all examples given by the Ohio Department of Education, but with the intent of controlling and manipulating another student. So physical or direct abuse is observed and could constitute bullying or harassment. Less direct is psychological, emotional, or verbal abuse or coercion. This could involve relational, controlling behaviors, manipulating and or humiliating another student, obviously name-calling, verbal assaults and threats, spreading rumors. Sexual abuse obviously could fit into both the state and federal definition of harassment. And this would involve any unwanted sexual conduct, touching or attempted sex acts. Non-contact sexual abuse, such as voyeurism, threats, pornography, or insults and intimidation based on sexual orientation or sexual identity. A new topic, or something that's also included in Ohio's training on harassment and bullying, is electronic or technological abuse. And this is an issue that we should highlight. Unwanted or excessive texts or posts on the internet, causing emotional distress and serving no legitimate purpose, stalking and manipulation that occurs online. It's been my experience that school administrators or teachers sometimes want to avoid or ignore conduct that is happening online. And I'm sympathetic to that. If there is conduct that is occurring on the internet, on a personal electronic device, not at school, it's solely happening online, why should that be the school's problem to deal with? However, I think it's also true that when parents observe online harassment of their sons or daughters, the students, and they see bullying conduct that's going on online, parents don't necessarily have anywhere else to turn. The police are not always the most helpful when it comes to harassment that takes place online. And it can be nearly impossible to convince a social media provider, a Facebook or an Instagram website, to remove content that has been posted on someone else's site. So parents, of course, are turning to the schools. They're bringing in to principals Facebook posts or transcripts of online chats and asking the school what they can do to help. In my view, as long as there is a nexus or connection to the school community, I think it's appropriate and perhaps even necessary for a school to intervene in online harassment. And obviously ODE, including it as a part of this presentation, agrees that schools have some role as trained professionals in the community in rooting out harassment to intervene in an online situation. Bullying and harassment is likely to take different forms for different age groups. As adolescents grow older and become more engaged with electronic communications devices, that form of bullying and harassment becomes more prevalent. And again, with teenagers, as they get older, there's a more likely possibility of teen relationship abuse. So there's different forms of harassment depending on the different age groups. Studies have shown that a predictive pattern of future victimization and perpetration in adult relationships occurs in teens with a history of bullying and aggressive conduct. So now that we've discussed recognizing harassment, understanding the different definitions, and knowing some of the conduct that can be considered bullying, harassment, or intimidation, I want to talk for a few minutes about what school professionals can do to prevent it from occurring in our schools. And first and foremost, as educators, it's our responsibility to model positive behaviors for our students, to be good role models. Whenever you are in a respectful disagreement with a colleague, or firmly but kindly correcting a student's behavior, you have an opportunity and responsibility to model positive behavior for our students. Role modeling positive behaviors is perhaps one of your most important responsibilities. And in doing so, you're teaching our CPS students that the skills that they can use to prevent and intervene in bullying and harassment that occurs outside of your presence. You're teaching them skills that include effective and respectful communications, self-advocacy, recognizing and respecting boundaries, critical thinking skills, and analyzing the motivations behind one's conduct, empathy, and the capacity to respond and to intervene when they observe a friend in a dangerous situation or an unhealthy relationship, and also the responsible use of technology and electronic communications. These are all skills that our students can, should, and must learn to avoid situations that may involve harassment or intimidation. And these are all good things, but as I was reading the ODE materials to prepare for this presentation, I was thinking to myself that preventing bullying and harassment is much easier to describe in a presentation than it is to practice. Given the complexity of student discipline, parents who refuse to believe their students have engaged in misconduct, or students with disabilities and IEPs for which you have to hold a manifestation hearing in order to discipline the student. I'm sure that if I was a teacher observing in a high school cafeteria or on a school playground, there would be days when it would be easier to turn my head and ignore a situation than it would be to step in and intervene. I think there is probably something truthful about the statistic that I quoted you earlier, which said that 70+ % of teachers self-report that they always intervene when they observe harassment or bullying conduct, but only 25% or less than 25% of students observing their teachers say that they always intervene when the teachers have observed harassing or bullying conduct. I think there's something truthful about that. In any event, given all the complexities with parents and students that's involved in student discipline, I thought ODE's recommendation for intervening in a situation was pretty clear, concise, and effective, and I wanted to share that with you. They recommend a 3-step process. One is to say it. The teacher or school professional engages immediately and says out loud what he or she just observed. To say it loud enough that other students can hear that the conduct that they've observed is not acceptable. The second step is to claim it. ODE recommends that the teacher or school professional owns his or her space and makes clear to students that offensive or hurtful words or behaviors are not tolerated in this space. To claim it. And then the third step is to stop it. The teacher or school staff, school professional tells the student that the words or behaviors are not to be used again in their presence. This is the same strategy I use and you probably use with your own kids. When you tell them that kind of behavior is not tolerated in our family or in our house. And it's the same advice that ODE is giving for our schools to say, I've seen your behavior, I see it, and I'm saying it, and that I'm claiming it. This is our school, this is our playground, our classroom, and that kind of behavior is not going to be tolerated here. It's simple, it's concise, and I wanted to share that with you. Another helpful nugget from ODE and the training materials. ODE advises that bullying is not a mediation issue. It's critical that you not try to mediate a situation of bullying or violence. One of the characteristics of bullying interactions is that there is a power differential between the student who's bullying and the student who's being bullied. The nature of bullying is a power play, one stronger or more popular student targeting a weaker student with presumably less weaker social skills. Think to yourself of the situation where Johnny says to the teacher and in the presence of other students, "Come on, Susie, we were just playing, right? You didn't take any offense by what I did." Again, you're aggravating, by trying to mediate the situation, you're aggravating the bullying and putting Susie in a pretty compromising and weaker position. So ODE recommends that when you observe bullying or harassment, that you separate the student who was bullying and the student who has been bullied or harassed. Final point that I'll address in this presentation is the reporting that's required by law and by board policy at CPS. The first thing you should know is that as an employee of CPS, reporting bullying and harassment, intimidating conduct is not optional. Ohio law mandates that all school districts have a policy that prohibits bullying, harassment, and intimidation with a specified legal definition and specified requirements relating to reporting, investigating, and intervening. And I will discuss our CPS board policies momentarily, but you must also be aware as a school employee of your obligation as a mandatory reporter of child abuse and neglect. Ohio law requires that all teachers, school employees, and officials and administrators must report any information they have of suspected child abuse or neglect. And this is the call that we make to 241 kids. In almost every case, the principal or administrator in your building should be informed of the incident, and there should be a clear understanding that either the principal or you have the responsibility to call 241 kids. From the legal department, this is a situation where it is almost always better to be safe than sorry. As of March 2007, Ohio has a law that makes it a criminal offense for a school official to fail to report suspected child abuse or neglect. It's a first-degree misdemeanor in Ohio, and it carries a sentence of up to 6 months in prison or a $1,000 fine. So, as a school employee, you are a mandatory reporter of child abuse and neglect. Second, let me describe CPS's board policies for reporting harassment and bullying. Because the definitions under federal and state law are different, CPS has two separate board policies. Both should be in the materials attached to this presentation. Board Policy 5517.01 relates to the state definition of bullying, harassment, and intimidation. Under this board policy, you will note that any students and parents are directed to report any conduct of bullying, harassment, or intimidation to any teacher, school administrator, or staff member. So you should be prepared that you're an appropriate person for a student or parent to report this sort of conduct. You should be prepared for a student or parent to report this kind of conduct to you. Your responsibility is not necessarily to investigate the situation, but to promptly document the incident, keep a record of the report, and provide the information to your school principal or other designated administrator. The principal has the responsibility of investigating and to take prompt action to respond. Second, Board Policy 2260.02 relates to the federal definition of harassment, a component of which must be that it's based on protected status. Again, race, sex, disability, religion, national origin. In that case, staff are also directed to report to the principal or designated administrator, and the principal or designated administrator is directed to report that conduct to the General Counsel's office or Director of Human Resources for further investigation and resolution. So those are our board policies. Our office, the Office of General Counsel, has developed a form to assist with the reporting of harassment. The form's available on the district's website and is attached to these materials. The report asks for information that will be used in investigating the alleged harassment. It includes a name and description of the complainant, that could be a parent or a student, a third party, a name or description, and if known, the protected class of the person reporting the allegation and the person who the allegation is being reported about. The nature of the allegation, any facts that you have, any witnesses that could have observed, any documents that were generated or witness statements, emails, anything that our office could use to help to investigate an allegation of harassment or bullying. There's two special topics I want to discuss briefly related to your obligation to report harassment. The first is that I'm often asked what someone should do if, when reporting harassment or discrimination or bullying, the person reporting asks for confidentiality. In my experience, and this may be surprising, it is best to avoid promising confidentiality to someone who is making a report of alleged discrimination or harassment. It's often unavoidable. The person will say, I'm only reporting this if my report can be kept confidential. And I want to describe why we try to avoid promising confidentiality. To read from our board policy, if a complainant requests confidentiality, the district will take all reasonable steps to investigate and respond to the complaint consistent with the request for confidentiality. But the district must evaluate the request for confidentiality in the context of its responsibility to provide a safe and non-discriminatory environment for students and staff. The reality is that it is often impossible to investigate an allegation of harassment without disclosing the person's identity who made the allegation. And oftentimes the person's identity is revealed by the content or the nature of the report itself. Moreover, CPS has an affirmative obligation. It is the law that we root out discrimination and harassment, and at times our responsibility to stop harassment or discriminating conduct that the person's request for confidentiality gives way to CPS's obligation to stop discrimination and harassment. And more importantly, as we discussed, CPS employees have an obligation to report suspected child abuse or neglect. And that's an affirmative obligation, such that notwithstanding a reporter's request for confidentiality, we have the obligation to report it to ODJFS through the 241 Kids hotline. So that addresses confidentiality. The second special topic related to reporting is retaliation, which is always prohibited at CPS and under the law. CPS absolutely will not tolerate any instances of retaliation against a person who has made a good faith report of discrimination, harassment, or bullying. And just to emphasize, the retaliation is prohibited against anyone who makes a good faith report. It is not necessary for the report to be substantiated. The fact that a report may not be substantiated is irrelevant to the prohibition against retaliation. Students, parents, and staff have an absolute right to report what they perceive to be harassment, discrimination, bullying conduct. And whether or not the report is ultimately proven or substantiated, the person cannot be retaliated against. This concludes my presentation. As I understand, The materials associated with this presentation will be attached to the presentation. So you should have CPS's board policies related to the state law definition of harassment, intimidation, and bullying, CPS's board policy on the federal definition, which of course includes that it's based on a protected status, the General Counsel's harassment reporting form, as well as materials from the U.S. Department of Education Office of Civil Rights and the Ohio Department of Education. Specifically, two websites to mention. The federal website related to bullying activities is stopbullying.gov, and there are lots of materials on that website that you may want to follow up and take a look at. And as well, the Ohio Department of Education has materials on its website related to bullying and harassment. So I thank you for tuning into this presentation.
Daniel, I want to thank you for the wealth of information regarding this very important topic. We have some very interesting questions as far as that might be on the mind of our audience, so we'd like to propose those and see what your responses might be. First, how does teen dating violence fit into this presentation about harassment, intimidation, and bullying?
Yeah, sure. Teen dating violence was added as by the Ohio General Assembly as one of the topics that needed to be discussed and trained on, that our teachers needed to be trained on about 3 or 4 years ago. And it fits, for obvious reasons into issues of harassment, intimidation, and bullying. It actually, teen dating violence would meet both the state and federal definitions of harassment. Under the state version, it is expressly a part of the definition of intimidation and bullying and harassment. And under the federal definition, because it's conduct that would be based on sex or based on gender, it would also fit into the federal definition of harassment. So it's been a part of the law for about 3 or 4 years, and fits neatly into both topics.
What additional resources are available related to bullying, intimidation, and harassment, not only within the community, but especially as far as Cincinnati Public Schools?
Sure, and that's kind of where we ended. My presentation was to talk about that both the Ohio Department of Education, the Federal Department of Education have resources available on their websites that address those topics. And so if you're looking for resources for your school or resources, kind of general information, there's information on both of their websites. Here at CPS, probably your the first person you'd talk to is the school psychologist, and they can deploy resources from our student services department, and obviously other resources that are available in the Cincinnati area. The Department of Student Services would probably be your first stop. We've got professionals that are trained on these issues. And then obviously the Office of General Counsel, part of what we talked about, part of the responsibility of school administrators and teachers is to report these issues, and one of the offices at CPS is the Office of General Counsel. And so another place that has resources related to these issues.
What legal liability does a school district face regarding these issues?
Well, both the school district and individuals, there's liability issues involved. School district can be liable for instances of harassment, particularly with respect to students, if it's caused or not stopped by members of our employees, our staffs. In the employment context, if it's a supervisor that's caused harassment, the school district can face liability. There's Typically, in a liability, the question is, who's responsible or who caused it, and if it's student-on-student harassment or student-on-student bullying, it's not obvious to see how the school district could be liable. Our responsibility is to make sure that we have resources available, that the way to report these issues is clear, that when it's reported, we investigate promptly, that we do what we can to stop the harassment. And if we're not doing that, then the school district faces liability. On the individual side, in Ohio, harassment, there's a cause of action that can be brought against an individual for harassment. In the federal employment context, lawsuits can only be brought against an employer, but in Ohio, individuals can be liable for harassment. And then one of the other things we talked about was failing to report suspected abuse or neglect. If a teacher becomes aware or even suspects that abuse or neglect is happening, and fails to report that, there's criminal liability that's possible as well.
In addition, what about the individual liability as an educator?
Yeah, I mean, if you're using your good faith efforts, taking the steps that we've talked about today, the school district is obligated to defend employees of the district. There have been times, certainly, where there's been misconduct by an administrator or a teacher where the school district has obviously defended itself, but the misconduct is so egregious that the school district has chosen not to defend the individual teacher or administrator. But for the most part, if you're acting in good faith, if you're exercising good judgment, the school district is bound to defend its staff and teachers, and we do.
What is involved in an investigation when a report is made to the school regarding these issues?
First of all, importantly, I think the Ohio Department of Education, one of the things I talked about in our presentation is trying to resolve it at the lowest possible level. And so, we talked about trying to stop it and explain that that kind of conduct doesn't happen here at CPS. It doesn't happen at our school. It doesn't happen in the cafeteria. To separate the two students if it happens to be a student-on-student case. But if a case rises to the level of our office, the Office of General Counsel, we talked about the reporting form that can be used if a parent wants to file a formal complaint, or if you've observed something that rises to the level of a formal complaint. Our office would receive that report. It's particularly important to note in that report who the witnesses are to the harassment, any kind of written statements that are available, if there's witness statements, if there's email, if there's text messages. We would want to gather all of that evidence first. That's usually, our first step. And so we would receive that report. The district actually employs a professional investigator who we use and deploy out to schools to talk to teachers, talk to administrators, talk to parents at times. And there are some matters that that we handle directly as lawyers. So the investigator is available, but there are some cases that the lawyers investigate. Once we've, usually my first step in conducting an investigation is talk to the complainant, the person who's making the complaint, if that's a parent, if that's a teacher, whoever's complaining about what occurred, and to try to get the story from that person, and I ask them, for all of the information they're willing to share. I explain to that person that I need to talk to the other individuals involved, that they may think that that we should only talk to that person, but it's only fair to get both sides of the story, and I explain that. I usually explain about confidentiality, that I have a conversation with them about how we want to respect their need for confidentiality, or their request to remain anonymous at times. Sometimes folks will request that their complaint be anonymous. Excuse me. But that, as a school district, it's our responsibility and the law that we stop harassment from occurring in our schools. And be that in the student context or the employment context, that we have to stop it. And so that the request for confidentiality is honored to the extent that we can, but that it's our ultimate responsibility to make sure that the harassment or discrimination is stopped. So that would be part of my conversation with the complainant. And then I would talk to any other witnesses. Sometimes we would have the same kind of witness interviews to discuss with those folks what they observed, share their side. And then usually you start to kind of form a picture of what happened, but we sometimes can find some objective evidence. Sometimes that's video evidence, sometimes that's written statements or emails, and try to put the story together. After we've made a determination of what has occurred, then if there is some kind of harassing conduct, then it's our obligation to do two things. One is to try to stop what's occurring, and secondly, to remedy whatever harassment has occurred. So that may mean having a counselor talk to the student that's been harassed. It may mean to put protections in place on an ongoing basis. So that's kind of how our office handles investigations of harassment.
Is this investigation different from when it occurs as far as at the school as compared to when you're involved?
Sure. I think the process is basically the same. Not all complaints get up to the Office of General Counsel, but I think a principal responding to a complaint would basically take the same steps. Would talk to the complainant, would talk to the other witnesses, would try to gather whatever other objective evidence might be out there, put the story together, and then respond. As far as the code of conduct, obviously conduct that's deemed to be harassing fits into the code of conduct. It would be something that the school district would respond to with discipline if that occurred. So yes, same kind of process, just at a different level, I would say.
Do teachers need to be concerned that conduct they observe meet legal definitions of bullying?
Before they report? No, conduct should be reported even if it doesn't necessarily, the teacher doesn't know, does this meet the legal definition or not? Conduct should be reported. The teachers and our staffs aren't paid to be lawyers and sort through the legal definition, and they shouldn't need to do that. They shouldn't do that before conduct is reported. A good example is the child abuse and neglect standard. It's not, the duty is not triggered by conduct. The duty to report is not triggered by conduct that is abuse or neglect. It's what the teacher suspects may be abuse or neglect. So when a teacher, school employee suspects abuse or neglect, that duty to report, in that case to 241 kids, is triggered. And that's why our office, again, we talked about this is an area where it's better to be safe than sorry. Whenever the teacher or staff suspects that that's going on, it's always our recommendation, the first step, to report that.
What can I do if I believe that I'm being bullied by either administrator, fellow teachers, parents, and or students?
Yeah, this is a concept that's being talked about in employment law circles now, whether there is a legal concept of employee bullying. There certainly is a concept of employee harassment under federal and state definitions. What I think is not always clearly understood is that for bullying to rise to a cause of action in the employment setting, it needs to be based on protected. It has to be based on protected status. So, for example, if you're being treated differently, or if you observe another employee being treated differently or harassed based on race, religion, national origin, gender, disability, age, one of the protected classifications. That's conduct that the courts and both state and federal law prohibit, and the courts find to be a cause of action. It's not illegal for a supervisor to be unfair to an employee. There's no legal prohibition of that. However, again, unless it's based on, if it's because of the person's race, religion, disability, age, national origin, then that's a legal conduct. That being said, we hope our administrators are treating our staffs fairly, and there are union protections for almost all of our members, and so probably their union contract or talking to their union representative would be the course that I would recommend, I guess. I don't like to see union grievances, but of course, that's why the unions are there, and that's why the union contracts are in place, and so they should be talking to their union rep.
Why is bullying more prevalent today as compared to when I was in school?
Well, I mean, there's new laws that protect against bullying in Ohio, which we've talked about. Federally, it's being talked about. And in almost every state, there are new laws that protect students against bullying. I think, we understand it better. We are trying to be proactive. We also understand that it has consequences and severe impacts on the students who are being bullied, and so that's the reason for the laws, I think. And so I think that's why. You're hearing more about it, is that it's a topic of conversation in almost every state house across the country as states try to respond to what's going on in our schools.
Daniel, any closing thoughts regarding this very important topic?
I'll kind of end where we started, and that is to say that this whole training that we've done today, and the other segments that are being prepared and delivered by other professionals, to me it's it's a recognition by the state that our schools are supposed to be pillars in our communities. That CPS is a good example. We've built beautiful schools in every neighborhood around the city practically, and I think the community looks to the schools and should look to the schools to be staffed with professionals who have some background in these areas: harassment, intimidation, and bullying. Some of the other topics you're going to hear about as a part of this training: suicide prevention, human trafficking, all the topics that are covered. The community looks to the schools to have professionals who have some background in these areas, are trained in these areas, and when parents or community members are looking for someone to turn to in the community, they should be able to look to our schools, I think, and that's why I think the training is so important. And that you should have some background. All of our staff should have some background in these areas, so that if a member of the community, a parent, a student comes to anyone in our schools, any teaching professional, administrator, that it's not, we're not looking for someone else to send them to, but that this is an appropriate place, that our schools are an appropriate place to report this kind of conduct, and that we know something about it and can do something about it. So, again, I think it's a worthwhile way to spend a couple of hours, every couple of years, and that's what the law requires. So,
we want to thank you for your expertise, especially from the legal perspective, regarding this very serious subject of intimidation, harassment, and bullying.
Sure. Thank you.